To the Justice Committee's 6th meeting of 2020. We have apologies from Convener Margaret Mitchell and Jenny Gilruth. Agenda item 1 is an evidence session on a legislative consent memorandum on UK Parliament legislation, namely the Terrorist Offenders Restriction of Early Release Bill. The bill touches upon devolved matters and the Scottish Government is recommending that this Parliament gives its consent to the UK Parliament to make the relevant provisions in the bill. I welcome Humza Yousaf, Cabinet Secretary for Justice, and his officials, Nicholas Duffy, Branch Head, Criminal Justice, Police and Fire Division, and Philip Lamont, Head of Criminal Law Practice and Licensing Unit, Scottish Government. Can I refer members to paper 1, which is a note by the Clerk? And can I invite the Cabinet Secretary to make a short opening statement on the LCM, following which there will be an opportunity for members to ask questions.
Thank you. Thank you, Convener, for inviting me to give evidence on the Scottish Government's legislative consent memorandum in respect of the UK Government's Terrorist Offenders Restriction of Early Release Bill. I appreciate that Convener and the committee have been able to prioritise consideration of this LCM in light of the timescales at Westminster for consideration of the bill. The bill has been developed in the space of a few days, with the bill being introduced by the UK Government into the House of Commons just over 1 week after being announced. While I can understand on occasion there is a need to legislate with such speed, there are of course risks in so doing, especially in the area of enforcement of sentencing, which this bill relates to and which many members of this committee will have commented in the past, of course, is extremely complex. As members will be aware, the bill ends the automatic early release of individuals receiving determinate length of sentences for those convicted of terrorism-specific offences or convicted of terrorism-related offences. The bill provides a new process for consideration of discretionary early release at the 2/3 point of sentence. The bill affects all those receiving fixed lengths of sentences, so both long-term sentences, i.e. 4 years or more, and short-term sentences, those of less than 4 years. In this Parliament, we abolished automatic early release for the most dangerous categories of long-term prisoner through the Prisoner Control of Release Bill in 2015 and severely restricted the availability for automatic early release for other categories of long-term prisoner. The effect of this bill on long-term terrorist prisoners is therefore quite limited. The main effect will be to adjust the point of sentence when parole can be considered from the halfway point to the 2/3 point. For those receiving sentences of less than 4 years, the effect is more significant, with automatic early release ended and a new right to be considered for parole being introduced. This is UK Government policy. Our proposal to lodge an LCM should not be seen as support for UK Government policy. I do have reservations about the effectiveness of this policy, particularly in relation to de-radicalisation. But in order to implement their policy, the bill needs to make some changes which affect the executive competence of Scottish ministers, which is why a legislative consent motion is required. It's important for the committee to note that the Scottish Government could not legislate for terrorist offences and sentencing of terrorist offences. This is a reserved matter. The functions affected by the bill, which require the LCM, relate to powers of Scottish ministers to release prisoners either on home detention curfew or on licence. In this latter category, it should be noted that the function to release is only ever used if the Independent Parole Board has recommended release and no change is proposed to that relationship. So the overall effect of the UK Government bill is that new arrangements for release are put in place for terrorist offenders, which requires adjusting the functions of Scottish ministers in the area of release of prisoners as listed in the memorandum. To minimise the risk of error and confusion in the law arising, the Scottish Government LCM has been lodged so that the necessary adjustment can be made in the UK Government bill. Of course, happy to take questions.
Thank you, Cabinet Secretary. Do members have any questions? Oh. Liam, I think.
Thanks very much, Convener. Thank you, Cabinet Secretary, for those helpful opening remarks. I think it's fairly clear that I don't think anybody would dispute the need to avoid a situation where those convicted on terrorism offences are automatically subject to early release. But I would certainly share some of your misgivings about the speed with which this legislation has been brought through, the fact that it doesn't appear to address the issues around de-radicalisation. But I suppose the one substantive point would be around the issue of the retrospective application of this legislation, and whether or not that exposes the Scottish Government to legal challenge in relation to those who may see this as an infringement of their human rights.
Yes. Can I thank Lee MacArthur for those helpful comments? And I watched the debate in the House of Commons, or I went back and watched the debate in the House of Commons, and I would associate myself with much of the remarks made by a number of the Scottish MPs, including Alistair Carmichael, who I thought was very thoughtful in his consideration of the bill. And questioned the speed and the need for the speed of the bill. So I do have those reservations, and I put them again on the public record. In terms of legal challenge, I looked at my colleagues on my left and my right, but I'm pretty sure I'm right in saying that the risk for legal challenge lies with the UK Government. It is their legislation, despite the fact that we are proposing this LCM. The reason why the UK Government are confident, they've said as much in the public record, is that what is not being changed is the length of a sentence. But what is being changed through this legislation is when the release of that terrorist offender can happen, be it for long-term or indeed short-term prisoners. So the actual sentence length isn't changing, but it is the enforcement of that sentence that is being changed. There may well be a legal challenge, and again, the UK Government have acknowledged that, but they are firm in their belief that it aligns with and is compatible with ECHR requirements, particularly Article 7. But again, just again, to be absolutely sure, the legal risk would lie with the UK Government in terms of legislation.
Well, yeah, it will be ultimately Westminster legislation, so that's where the legal challenge will lie.
So just to follow that up, I mean, have you taken separate legal advice around that point? I mean, I know there's protocols around admitting such things, but it's clearly been a part of the debate around this, like one aspect of the debate around this legislation. It would appear prudent to be exploring that, even if the risk perhaps lies with the UK Government rather than the Scottish Government.
It would be prudent. I mean, the member knows I can't comment on even seeking legal advice, let alone whether or not legal advice has been given by the law officers or not. But he'd be right in his assumptions around how it would be prudent to of course, look at the legal effects of the bill and the legislation. But of course, I couldn't, as a member of the government, as protocol dictates, confirm whether we received legal advice or not.
Okay, John.
Why are you pandering to a racist UK Prime Minister, Cabinet Secretary?
I have to say I take an enormous exception to that. As somebody who's been at the forefront, I'm afraid, of racist abuse, probably more so, I suspect, than John Finney has ever been in his life. I would suggest to him that he might want to ask that question again in another way or another format. This is not pandering. Ridiculous to suggest that is pandering. If we didn't promote this LCM, and I have to say, on balance, I take that view as one, as a considered view, not one that we rushed into, although of course the timescales were against us. I took it as a considered view because I do not want there to be error or confusion in the law. I'll give you one example. If we didn't propose an LCM, or if LCM was rejected by this Parliament, the law, as it would stand if the UK Government decided to continue with the legislation, which they've told us they would, the law would say that a prisoner, a long-term prisoner, in relation to terrorist offences, I'm right in saying that the parole would be at the 2/3 point.
Yeah, the UK Government are proposing in their bill that a long-term terrorist offender can be considered for parole at the 2/3 point. In Scotland, currently, a long-term prisoner who's committed any offence can be considered
At the halfway point.
At the halfway point.
So there you would have some confusion in the law in terms of when a prisoner in Scotland with a terror-related offence would end up going in front of the parole board. Would it be at the halfway point or would it be at the 2/3 point? So there's clearly going to be, if we do not pass this LCM, error potentially, but certainly at the very least confusion. Now, if the argument coming back to me is, well, why don't you just legislate yourself? Again, I think the member would be aware that when it comes to the sentencing of terror offences, that's reserved to the government in the UK. So I'd ask two things of the member. One is, please don't suggest to me a charge that I'm pandering to racism or a racist Prime Minister, somebody who's been on the other side of that, and I suspect he's probably very rarely been on the other side of that. But secondly, when it comes to understanding the LCM and supporting the LCM, which of course he has every right to oppose that, and I suspect he will, do not take the government lodging an LCM as support for the UK government's policy. I have deep reservations about the fact that this probably just kicks a problem down the can. If you want to tackle de-radicalisation, then you're much better looking at the work that we do and prevent up here in Scotland, as opposed to keeping people in prison for longer. But that is another policy discussion.
Can I unreservedly apologise to the Cabinet Secretary for my clumsy framing of the question? I know that the principled stance the Cabinet Secretary takes in regard to all matters regarding equality issues, including racism, so there was no offence intended. Cabinet Secretary, why are we here? This is a Justice Committee of the Scottish Parliament. We consider a lot of detailed proposals. I have 3 sheets of paper in front of me here. I don't have assessments. I don't have... I understand what the perceived problem is. What's the problem we're seeking to address, and what other routes were considered?
So again, it's a UK government policy, and he's right. The member is absolutely right that our preference would be, my preference would be, and I said as much to the Justice Minister, the Justice Secretary in the UK government, that he took his time to consider a bill, brought it forward with considered time. His argument back, and I've got to accept his judgment on these things. His judgment was that the legislation was needed because of the potential imminent release of some terrorist offenders across the United Kingdom. But of course, if we had more time, we would be able to have, or the UK government would be able to have, because remember, I can't legislate on this, UK government would have time to do consultation, further discussion with stakeholders, etc., etc. So I agree, this is not, for me, the most favourable approach, but it is an approach the UK government is taking, and therefore I have a judgment call to make about, and a very fine one to make, about whether supporting it or not supporting it could lead to error and confusion within the law, which would be in absolutely nobody's interest.
Would it be the Cabinet Secretary's view that the concern is about shortcomings regarding supervision, rehabilitation, risk assessment, which in themselves wouldn't necessarily require a legislative change? They would require a robust examination of any shortcomings and steps to address that, rather than rush days to turn around 3 bits of paper for law, and you know that we pore over issues for months. Yes. About sentencing policy.
I really don't disagree with his principal objection to the speed of legislation. I share those reservations. I've communicated as much to the UK government. And I'll go back to my earlier point. You know, if you want to tackle the issue of radicalisation, there are numerous reports and research that shows that actually prison is one place where people are further radicalised, not de-radicalised. And I would point the committee, if they wish, to remarks by David Merritt, whose son, of course, was killed in the London bridge attack, Jack Merritt. And I thought his remarks, David Merritt's remarks on this bill, really are food for thought to us all. So I want to make the point very forcefully as I can in the record that I do have deep reservations and misgivings around the approach. But my fine judgment and balanced judgment that I have to make is, if I do not promote this LCM, then there will absolutely be errors and confusion in the law of how terrorist offences are then dealt with, and there's no obvious way in how to deal with those. And we gave one example in terms of what the law would say around parole for those who are long-term terrorist offenders, and what actually Scottish ministers' competency would then be. So would a long-term offender go out in the halfway point, or be eligible for parole at the halfway point, or at the 2/3 point? And there's no clarity in that. and therefore it's better to have clarity. And what are relatively small numbers that we're talking about in Scotland, about this 5 people in Scotland, 5 individuals that this would potentially affect. But I share a number of his reservations.
Thank you.
Thank you. James?
Thanks a lot, Convener. I mean, I think the Cabinet Secretary and members are right to express concerns about the speed with which this legislation is being pursued. However, I accept the Cabinet Secretary's taken a prudent approach to this, and that I don't think we would want to see a situation where there's inconsistency in the way terrorist prisoners have been dealt with in relation to release in Scotland and the rest of the UK. So I think a sensible approach has been taken here. You mentioned that there were affected 5 prisoners in Scotland. Without getting into specific examples, can you kind of give a bit more detail on the types of prisoners that would be covered by this?
Can I thank James Kelly for his remarks and understanding the approach we're taking. It's interesting, he used the word inconsistency, and I actually, when I was first discussing this issue, I kind of used the same word myself. And then actually, it's probably just a slight nuance that probably isn't the correct word, and I reflected on this myself, that I wouldn't mind if there was a slightly different approach in Scotland than there was in England and Wales. What worries me is not necessarily the fact there could be an inconsistency of approach or difference in approach, but actually there could be error and complete confusion about the regime overall. But I really welcome his remarks on the approach that's being made. You're right, it's difficult for me to go into details. What I would say in the general, I think this is widely understood anyway, that where the problem in England and Wales focuses on what you might call ISIS-inspired terrorism, often just for shorthand, often called jihadist or Islamist ideologies, and that is where the problem lies in England and Wales. It'd be fair to say that in Scotland we do not have the same level of issue or problem, and often, and these are public cases, so I can reference them. You'll know that often the cases that are dealt with in terrorism related offences are often related to the far right, and are in some cases to paramilitary activity as well. But these are cases, again, that are mentioned publicly. I couldn't go into details of how many in each one and so on. You would understand the sensitivity in me doing so. But it'd be fair to say that where in England and Wales this legislation be brought forward largely to deal with an ISIS-inspired type of terrorism. In Scotland, I'm pleased to say that I think through the PREVENT work that successive administrations and political parties have signed up to, the approach here in Scotland means that we do not have that same problem. Touch wood, but that's not to be complacent. That couldn't be a problem in the future. It obviously could be.
Okay.
Thank you. Do members have any further questions? No. In that case, I'll allow for a short suspension for the Cabinet Secretary to depart. Item 2 is a consideration of the legislative consent memorandum and the evidence we've just received. Do members have any comments? John.
Thank you, Convener. Yeah, I have a number of comments. I have to say, I think to use a phrase used by someone on the bench not that long ago, this is mince. This is an embarrassing situation where we have a Cabinet Secretary seeking to put the best possible tone on something that's completely unacceptable. I look at the papers that's in front of me here, and the guidance we get in relation to what we do in relation to a legislative consent motion, and we do detailed scrutiny on the committee on the basis of the memorandum. The memorandum is 3 pages. Now, we know that the bill is split into England and Wales and Scotland separate We have clause 4, which is disapplying existing powers. That's something that I wouldn't have thought someone of the political persuasion of the Cabinet Secretary would be coming forward with. We've set, and I quote from the paper here, Scottish Government has reservations about the pace with which this has been developed, and also that clarity in the area of law of enforcement of terrorism sentencing is important. Now, we would accept that, and public safety is absolutely paramount in any attempt to spin opposition to this as anything other than wanting to have the best possible laws made in the best possible way. The legislative consent motion tells us over just 1 week had elapsed between an announcement by the UK Government of this legislation and a bill introduced in the House of Commons. We learn from the Cabinet Secretary that actually it was a few days. And again, from the legislative consent motion, the Scottish Government, in promoting this legislative consent motion, is not offering a view in the substantive policy contained within the bill. We have separate legal systems. It shouldn't be beyond the wit of man or woman to operate within that. We're told there's no significant financial implications of the bill. What we don't have in front of us is a financial memorandum. We don't have a human rights impact assessment, a quality impact assessment, or a community impact assessment. Members of this committee know that we spend many months following consultation making important decisions about this process. And as I say, public safety is important, but I'm very keen to understand the problem that this is seeking to address. Now, if, as the Cabinet Secretary is saying, that the UK Government are concerned that this is about the imminent release of prisoners, then I ask, what is the rehabilitative programme that's being employed in prisons in England and Wales? What is the risk assessment that's been undertaken in relation to that? What role, if any, is there for the parole board? If there's failings in these quarters, and it would seem that there is, then I don't understand why, a matter of days later, we are considering this. I won't support a racist UK Prime Minister in his far-right endeavours, and I won't be supporting this legislative consent motion. Thank you.
Anyone else have comments? Liam.
Thank you. I have to say I've got considerable sympathy with some of the substantive criticisms of the process and the substance that John Finney's articulated in relation to the bill. I think the separate question it relates to the bringing forward of an LCM, and I think the Cabinet Secretary did, to my mind, set out a credible rationale for that in terms of an attempt to avoid uncertainty, confusion or error. I think, though, the points that John makes in relation to financial memoranda, human rights impact assessments and the like, I recognise the shortened timescales involved, but I think it is perhaps more than unfortunate that those weren't at least covered off in the papers provided by the Scottish Government in this instance. As I say, I think the fault in many respects lies with the UK Government in the timetable they've chosen to adopt in bringing forward the legislation, but I think it has unfortunately been compounded by perhaps decisions the Scottish Government has taken in terms of the way that it structured the LCM, and that's regrettable. And I'm not minded to go down the route that John Finney's suggested he will be going, but I think it would be entirely appropriate for the committee to register concerns in relation to some of that substantiating evidence and due process effectively that appears not to have been done in this instance, notwithstanding the tight time frames.
Thank you. Anyone else have a comment to make? I agree with a lot of what Liam's saying and John, but I did accept the Cabinet Secretary's rationale for doing this to avoid legal confusion and just use the very tight timescale. We do have to make a decision today. So can I ask if members are agreed that the Scottish Parliament should give its consent to the relevant provisions in the Terrorist Offenders Restriction of Early Release Bill? So, John, dissenting, will we mark you down as dissenting on the report, or would you like a vote?
I'm relaxed as long as it's recorded.
As long as it's recorded.
Thank you.
That's fine. Content with that as a committee? Excellent. We'll ask the clerks to produce a short factual report on the decision in due course. Thank you. So that concludes the Justice Committee's 6th meeting of 2020. Our next committee meeting will be this coming Thursday, the 20th of February at 9 a.m, and we will take evidence from members of the Scottish Judiciary on the Children Scotland Bill. And I close this meeting.